to all the relevant social platforms?
We absolutely have issued preservation letters because of the Discord and other devices. Yes, we have, and we will continue to investigate all of that.
What do you make?
Welcome back to the channel. Subscribe the channel if you are new. The assassination of Charlie Kirk, a singular, brutal punctuation mark after years of poisonous rhetoric on American political stages, has forced a legal and moral double take. What separates rancorous, caustic political speech from criminal incitement, and in the most horrific of outcomes, can the state answer with the ultimate punishment? The facts that prosecutors in Utah have already charged a 22-year-old suspect with aggravated murder and that authorities say the accused left a note and later confessed in messages have set in motion a criminal case that, under state law, could carry the death penalty. That immediate, grave possibility changes the tenor of public debate and places Attorney General Pam Bondi's recent on-air pronouncements under a harsh spotlight. In an appearance on My View with Lara Trump, Bondi sought to draw a line between constitutionally protected expression and speech that crosses into criminality, saying in essence that, you can be hateful all day long, but not incite an attack, while also suggesting the Justice Department would, absolutely, go after people who cross that line. The prosecutor's hammer is already in the hands of county and state officials, and Bondi's words, as the nation watches a capital case unfold, read like both reassurance and a warning. Scrutinizing what Bondi actually said matters, because the language of prosecution and the language of politics have different burdens. On her Fox appearance, Bondi emphasized the government's duty to pursue those who incite violence and signaled the federal apparatus could play a role in tracking down not only the shooter but the atmosphere that made the killing possible. That comment dovetailed with other public statements attributed to her that suggested the Department of Justice would target hate speech that crosses a criminal threshold, a formulation that drew immediate pushback from constitutional scholars and civil liberties advocates. The outcry was bipartisan in tone if not in intensity. Critics warned that vague promises to go after hate speech risk chilling lawful dissent and invite politicized prosecutions, while supporters argued the justice system must be unflinching when speech translates into real-world bloodshed. Bondi later sought clarifications in the wake of backlash, and media outlets reported her office's attempts to draw a narrower line, that the government's interest is not in punishing abhorrent opinion but in prosecuting true incitement to imminent lawless action. The legal framework behind that narrower line is well established and unambiguous. Brandenburg v. Ohio, decided by the U.S. Supreme Court in 1969, remains the controlling standard for incitement. Under Brandenburg, the government cannot criminalize advocacy of violence or illegal action unless the speech is both 1. Directed to inciting or producing imminent lawless action and 2. Likely to produce such action. In plainer terms, a prosecutor must show the speaker intended for listeners to commit a specific, imminent violent act and that those words were likely to provoke it immediately, not at some indeterminate future time. That is a high bar by design, intended to shield even vitriolic political speech from criminal liability unless it is the functional equivalent of, light the fuse now. Any suggestion that the Department of Justice will broadly prosecute hate speech, without proving those elements would be constitutionally perilous. Where does that leave the present case? In practical prosecutorial terms, there are 3 separate but overlapping questions. First, whether the accused can be fairly convicted as the principal actor in a premeditated killing, that is the core of the aggravated murder charge. Second, whether anyone else, online voices, conspiracy theorists, or organizers, can be credibly accused of having incited or conspired to produce the attack. And third, whether the state or, plausibly, the federal government will seek the death penalty. On the first count, public reporting indicates prosecutors believe they have a straightforward, criminal case. Investigators say the suspect left a planned note, confessed in written messages, and was linked to the weapon through forensic traces, elements that feed the narrative of premeditation and personal culpability that an aggravated murder indictment requires. Those are the sorts of tangible, traditional proofs that juries and judges understand and that are squarely within the ordinary criminal law toolbox. On the second count, liability for third parties whose rhetoric might have contributed to the suspect's mindset, the evidentiary gulf is usually far wider. Prosecutors would need to show more than that a speaker expressed loathing, contempt, or even violent metaphors. They would need to show intent to produce imminent lawless action or active steps to coordinate or facilitate the killing. courts have consistently resisted charging people for abstract or remote influence. That is, unless there is clear evidence of direction, recruitment, or a concrete plan linking words to an imminent violent act. The difference between hate speech and criminal incitement is not semantic, it is a constitutional firewall. That said, modern digital ecosystems complicate the calculus. Targeted harassment campaigns, anonymous channels that coordinate violent acts, or explicit call to arms postings tied to time and place can transform speech into unprotected instruction, and prosecutors have successfully used conspiracy and aiding and abetting theories to charge actors who take practical steps to enable a violent crime. But the mere fact that an individual was exposed to hateful rhetoric online, even rhetoric that dehumanizes a target, rarely satisfies the immediacy and likelihood prongs of Brandenburg. The death penalty question is less abstract. Under Utah law, aggravated murder is the single capital felony. If prosecutors file the necessary notice within statutorily prescribed timeframes, the offense becomes death eligible and the case will follow a bifurcated trial procedure, guilt phase followed by a penalty phase. Utah code explicitly allows prosecutors to seek capital punishment for certain aggravated murders and imposes procedural safeguards, including a narrow window during which notice of intent to seek death must be filed after arraignment. The suspect's age, 22, does not trigger the statutory bar that applies to those under 18, that exception therefore does not save him from a capital charge. Practically speaking, then, the state can and, according to reporting, has moved to charge in a way that preserves capital exposure. Whether the death penalty will ultimately be imposed depends on aggravating factors, mitigating circumstances, jury verdicts, and appellate review. The statutory machinery exists. Using it is a prosecutorial and political decision. It is worth pausing on what political means here. Death penalty prosecutions do not occur in a vacuum. Elected officials, grieving communities, and the national media all exert pressure. There have already been public calls, from powerful conservative figures, urging that prosecutors pursue capital charges. In some quarters, the killing has been framed as not just a crime but an attack on a movement, and the politics of retribution have been loud. That context matters for two reasons. First, it shapes prosecutorial calculus about whether seeking death is worth the enormous expenditure of time and resources, given the intense appeals and the heightened standards courts apply in capital cases. Second, it fuels critiques that capital prosecutions in high-profile political killings risk appearing selective or vindictive, which can feed perceptions of victors' justice and further polarize public trust in the system. Those are not legal defenses but institutional realities that shape outcomes in the real world. From a constitutional and human rights angle, the question of whether to apply the death penalty at all remains intensely contested. Even in states that retain capital punishment, the trend nationally has been toward more restrained use of execution, with commutations, moratoria, and declining numbers of death sentences in many jurisdictions. Utah statutes permit death for aggravated murder and even contain historically notable options, such as a statute permitting firing squad under certain circumstances, but practical and ethical questions remain. Is the death penalty an appropriate response to political violence born of toxic speech ecosystems? Does its imposition deter future political assassinations, or does it merely escalate cycles of vengeance? Empirically, the evidence that capital punishment deters homicide is at best contested, and the moral calculus is necessarily political. When an attorney general publicly suggests a willingness to pursue aggressive penalties narrowly tailored to violence, the message can comfort victims' families and demand accountability, but it can also widen the fault lines around free speech and executive overreach. This brings us back to Bondi's specific framing and the public reactions it provoked. When a sitting attorney general says the government will go after people who engage in hate speech that leads to violence, the statement may be intended to reassure a shocked electorate. Yet, without precision, it risks conflating hateful ideology protected by the First Amendment with criminal incitement narrowly excluded from protection. Civil liberties advocates and some conservative critics alike warned of the chilling consequences. If left unchecked, enforcement language could be used as a cudgel against political opponents or independent journalists, particularly in a hyper-litigious, hyper-polarized environment where accusations travel faster than evidence. Bondi's subsequent clarifications, that prosecutorial focus is on speech that unlawfully incites violence, sought to walk back the broadest readings of her remarks, but the initial soundbite had already changed the national conversation. Yet the most morally urgent conversation should center on preventing recurrence. Even if the Brandenburg test forecloses wading into vaguer forms of hateful discourse, governments and platforms have other levers: targeted enforcement against threats, better evidence sharing between law enforcement and online platforms when concrete threats emerge, robust witness protection and event security for high-profile figures, and community interventions aimed at de-radicalization. Criminal prosecutions, particularly ones seeking maximum penalties, address culpability after the fact. They do less to stop escalation before the bullet is fired. If policymakers and platform leaders are serious about stemming politically motivated violence, they must pair constitutional caution with proactive prevention strategies that respect rights while addressing real threats. Finally, the human calculus cannot be obscured by legal formalism. The assassination has torn a family and a movement in parallel. It has produced mourning and fury and the predictable rush to blame. The law's job is to parcel responsibility fairly, to separate the person who pulled the trigger from the millions who voiced hateful opinions that remained, by constitutional design, lawful. That separation is uncomfortable precisely because it forces us to live with a paradox. A thriving democracy permits speech that many find immoral, even odious, because the alternative, government deciding what is acceptable expression in broad strokes, risks far graver harms to liberty. The proper path after this crime, legally and morally, is not rhetorical vengeance but disciplined, evidence-based prosecution of the person or persons proven to have committed or directly facilitated the killing, while policymakers and civil society work to choke off the networks and narratives that normalize violence. The death penalty may be legally available under Utah law and may be sought, but constitutional safeguards, evidentiary burdens, and the high bar for proving incitement should temper any rush to broaden criminal liability for speech in the name of prevention. For viewers and listeners who want to understand the stakes, this is where constitutional doctrine, forensic fact-finding, and partisan pressure collide. Bondi's comments crystallized a deep anxiety that words might be weaponized into deeds, and that anxiety deserves a forceful response. But that response must be anchored in the rule of law. Prosecutors will pursue a defendant whose fingerprints and communications place him at the scene. If evidence connects others to a coordinated plan, those actors should face the appropriate charges. What should be resisted is an expansive, vague campaign against ideas. The gravest lesson of the Charlie Kirk killing is not the temptation to silence rhetorical enemies, but the imperative to keep political disagreement from